Morning. Welcome to an oral argument session of the Sixth District Court of Appeal. My name is Mary Nardella. I have with me today Judge Brownlee and Judge White. We have one case to hear today. It's 24-1249 Randall Mechanical Incorporated versus the PHM Group Incorporated and Travelers Casualty and Surety Company of America. Counsel for appellant, we give you 20 minutes, obviously for both sides. The appellant is free to reserve any time. We typically reserve 5, but we can change that increment if you prefer. Okay, we'll do that. And then I'll remind both of you that we're being live streamed today and it will be on YouTube. So please come up when you're ready, counsel, and we'll go ahead and get started.
May it please the court. My name is Kim Ashby. I represent Randall Mechanical Inc., which is the appellant in this appeal. The final judgment against Randall should be reversed for all of the reasons that are expressed in the briefs, but I'd like to focus on first 2 issues that are, I think, the easiest for the court to deal with. Number 1 is the decision that the lien that was reported by Randall Mechanical was a fraudulent lien under 713-31, and as a result, awarded punitive damages up to the entire amount of that lien. One need look no further than the final judgment itself to see the inconsistencies of applying the statute to the facts in this case. What the final judgment says is that the finding of a fraudulent lien as a willful exaggeration of the amount due was as a direct result of payments, all of which came after the lien was recorded.
Was it also, I'm
No,
sorry,
go
Judge Nardella, go ahead.
Are you challenging the so the trial judge says this: Randall conceded on cross-examination that at the time of filing its amended claim of lien, it was aware of approximately $40,000 in direct payments for a boiler, the value of the work performed by Coastal, and a joint check issued to the subcontractor Tom Barrow. So if we're looking not at the time that the lien was, the first claim of lien was filed, but the amended claim of lien, is it your first contention that that's the wrong time period?
So it's the amendment to the claim of lien was just to correct a scrivener's error on the address. So the second lien, the amended lien, was recorded on the 25th of April, but the trial court didn't find that it was because of the one payment to Tom Barrow, the check for $21,000, but all of the checks, including all of the checks to Johnson Controls, Insight, Suburban, ICS. If I may, let me address the boiler issue.
Yeah.
The boiler issue is the specter that this is work, more materials that was not provided and that you would have actual knowledge that you didn't provide it. Okay. What the record shows as well is that there was substantial completion of the project. They closed out all their permits, their plumbing and HVAC permits. So that would have had to have meant they substantially completed the work under their contract. The fact that there was a direct purchase, if this wasn't a boiler, they had otherwise, as they were made, this is a repetitive project where they were building these types of things other places. DPOs or direct purchases by owners are done all the time. What they do is they descope that part of the contract, and there's an amount that's agreed upon for what that descope material was worth. We don't have any of that. What we know is lienors are not allowed to lien for unexecuted change orders to the good to increase my contract. That's what Hobbs says. That's been the law for a while because it's not part of the contract agreed at the time of filing. Here, the general contractor is saying, we get to assign a value that you should know about, and that creates a willful knowing of what that boiler should have been worth. And that should have been
back
taken.
you up for 1 second. I
Of
think the
course.
timing of the willfulness matters. And I want to know your opinion on when we should be looking, or when the trial court should have looked at your client's state of mind.
It has to be when the lien is recorded.
The first time,
Yes.
not when an amendment is
Why
filed.
doesn't the amendment matter?
The amendment at that time can be another filing, but there's nothing that happens between then and the first claim of lien other than the check that was cut to Tom Barrow for $21,000. $21,000 on $1 million plus lien is a very, 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 very small fraction.
Give me your best argument for why that's minor under the statute.
The statute was amended in 1991 to allow for disagreements and minor errors in computation. And this is exactly why. Because if a $21,000 miss is going to assess you with $1.4 million in punitive damages, nobody's going to lien anything.
So in assessing minors, we look at the overall value and it's a percentage. That's what you think.
That's what the analysis has been in all the cases that have looked at this. They look at the percentage of what, you know, what was the miss, how big and how big as a percentage of the cost of the original
So what's the
contract.
spectrum in the case law on minor? 5% is minor, 10% is not. What's the spectrum?
The Sherrard case, which is cited by Applee, it's 14%. And that was for workers' comp premiums, and he knew he didn't have workers' comp. He was just adding it to a wage burden, and he knew he didn't have it. And so there were two elements there. One, it's not, I know that I'm not incurring that cost, and it's a big percentage of the total claim of lien. And so in that case, the Sherrard court found that did support the fraudulent lien. Here, one item, a direct purchase by the owner, and the owner and the general contractor, where is the record evidence that says, here's what we spent on that? Here's the deductive change order that we're serving you with, so you can see the number.
But did you challenge that there was no competent substantial evidence to support that number in the record? Is that in the brief?
I didn't write the briefs. I think the court is aware of that. But yes, I think the competent substantial evidence on everything was challenged. Is the $40,000, if you don't tell me what the number is, let's just go there. I have to guess. And that's all it is. And so how is that not one of those disagreements, good faith disputes as to the amount due?
But counsel, you say good faith. I have two questions. First, where in the statute does it put some minimum amount of excessive lien as being, some sort of threshold? Like if you overstate the amount of the lien by 10%, 5%, I didn't see that in the statute. Is that in the statute?
There is if there was a mathematical formula, we would have led with that. And so we have to look at what the case law has said over the years as far as what is and what is not constitute a fraudulent lien.
Is there a case that says if there is a factual finding by the finder of fact that someone fraudulently, intentionally exaggerated the amount of a lien in the amount of $1,000, clearly very, very small in the concept, but it is completely false. A lienor says, you know what? I'm just going to raise my lien amount just a tiny bit. I'm hoping it's going to get under the radar and I'm going to file it, but it's complete fraud. Is there a case that says, well, it's complete fraud and there's competent substantial evidence to support the factual finding by the trier of fact, but because it's only $1,000, it's de minimis. Statute doesn't protect it.
The statute doesn't have a mathematical formula as we've all identified. But what we cannot escape is that these are punitive damages. The case law is consistent that it's a 768 punitive damage award, which means it has to be outrageous conduct. Is a $1,000 miss.
Well, going back to my hypothetical, complete intentional fraud, is that outrageous enough under the case law? Assuming that applies, let's assume that all the case law regarding punitive damages under 76872 applies here.
So the garden that grows from that $1,000 intentional overstatement. Okay, so in one of the cases that was cited, the types of intentional misapplication in the lien were things like HOA fees. You can't get HOA fees. It's not lienable under 713. You can't get mowing the grass fees. It's not lienable under 713. So if your $1,000 is, I took my wife to a Mother's Day brunch and we really, really had a good time, and I put that on the lien and said, ha ha. Is that outrageous? In the context, if it's a $2,000 contract, well, yeah, okay, it's now 50% of the contract.
Say it's $100 million contract.
If it's a $100 million contract, is it outrageous to intentionally add something that shouldn't be in there? That's the question you're asking.
Yes,
Okay, so
with fraud. Forget about that. Let's say there's just not even a shred of I'm not even going to pretend this is me taking my wife to whatever. It's like, okay, I know this is the amount for this item. It's $5,000. I'm going to increase it by 1,000, make it 6 without any basis. I know in my mind, and the finder of fact finds that I know in my mind, it's a $1,000 increase, completely unsubstantiated, just purely for my greed. Here we go. There it is. $100 million contract.
is it?
My question is, does that support an award of punitive damages, setting aside whether the amount of the overstatement might bear on the issue of damages?
So I think you corralled, all the questions, and the question going back to the standard that this court needs to apply to what was done is, are we looking at just a competent evidence review, or did the trial court err by applying the wrong standard and reviewing the statute itself and construing it in a way that is not consistent with the plain words that were used? So in your situation, is it a fact question of whether there was a willful exaggeration of a very minor degree, and that constitutes a fraudulent lien, is a separate question from whether punitive damages can be awarded because of that $1,000? What is the outrageous conduct in that $1,000?
Why are you saying that she applied the wrong standard? I mean, my understanding from the briefing was that your client believed she had a misunderstanding about whether she had discretion to impose the punitive damages award, or whether she had to do that. And then the ceiling would have been the discrepancy between what the amount of the lien should have been and then what the amount of the lien actually was. So where you're saying now, though, that she applied the wrong standard, are you saying that because you don't believe she applied the outrageousness standard?
Well, yes, but let me add to that. The final judgment, as outlined, that identifies what the basis for finding a fraudulent lien and awarding punitive damages. And there it all is. And it outlines all the payments that came after the lien was reported.
But does that include okay, so based on what you just said, my understanding is that there were several joint checks. So let's take away the moment when the initial claim of lien is filed, right? And if we look at the amended claim of lien being filed, were there joint checks? We know at least there is the Tom Barrow check, right? Were there other joint checks made to Randall's subs that Randall then would have been aware of prior to its amending the lien?
No.
Not one.
Not one, other than the Tom Barrow check is dated April 14. And the first lien was recorded on the 11th and the second one on the 25th. And that check was for $21,169.
Okay, so when Randall says that it believes, and I understand there's a discrepancy about whether this is a true amount, but what about the fact that it said Coastal at best would have performed $60,000 worth of work on the project? And then I understand there's a dispute as to whether Coastal even should have come in at all, what that amount is. But wouldn't that at least have put Randall on notice that now we have the Tom Barrow check that should have never been included in the lien, and now we have probably what they would think is about 60 grand that they know they did not do on that project, regardless of whether Coastal is properly there. Would those two things have been within Randall's knowledge prior to the lien being filed?
So we're adding the following text into this statute by taking those
Okay.
and saying lienor, notwithstanding your written contract and all the signed change orders to it, coming and going, up, down, deductive, additive, notwithstanding the four corners of the contract, we're going to require you to make an assessment and be right of what a deductive change order or deductive set off later that was not stated, that was not served up, what that may ever be. How do you do that?
Well, I was getting it from I understand your point. And I think that that's a fair point. I mean, it almost looks like, well, at least to some of this, and I think that the devil's really in the details here, because I think there's more than what we're referencing, at least by virtue of the final judgment. But if there is this dispute about that amount that's being owed, it looks like it could be a good faith dispute, which of course is a statutory exception. But what about the fact that I thought it was Randall who testified, obviously not the person, but someone testifying on your client's behalf is the one that said, we thought it was about 60K worth of work. Wouldn't they at least be on notice that they did not do the full contractual amount of work?
So every single job where there's any supplementation, where there's anybody else brought in as a lienor, I am super chilled now. I am super chilled from exercising my rights to lien the job. And not just my rights, everybody behind me, because we know that $595,000 was paid after Randall recorded its claim of lien, after Randall filed its lien foreclosure suit. And that's when the money started to flow. And I'm not even calling the general contractor out because everybody had to pay if paid. By the way, this is a 2021 contract, and I know it was not appealed as far as liability. I'm not going back on that. But, you know, what we had, because we're all in the trenches, we were still building stuff during the shutdown. And what happened was they ran out of materials, you know, because during 2020, when everything was shut down, we burned through all the existing building materials. And so that was a snowball. But what happens if I've got to guess what that number should be, and I better be right, or I'm going to be subjected to a fraudulent lien.
I'm sorry, counsel, you have to guess on what number?
What might come later in life in a deductive change order for completion for the general contractor or the owner's contention of completion of my work.
But then how do we resolve? I understand what you're saying. I think it's a fair point. And I'm wondering practically, how do we resolve that second or in the statute, right? In 2A, where it says, you know, that you can't, I mean, I need to have it right in front of me. I know Judge Nardella does, but thank you. I had the brief pulled up and not this. Okay, how do we resolve what you just stated with in which the lienor has willfully included a claim for work not performed? Now, I understand what you're saying. Well, how could I arrive at this number? My first question was, I thought your client gave us that number. And my next point would be, what are we to do with this language? I mean, they're at least on notice that 60K is work they have not performed, or that they have not performed some amount of work. So how are we to resolve that? Because I think the point you're making is fair.
So Hobbs says, you, the lienor, do not have lien rights for change orders to add work unless it's all signed up by everybody, okay? Because it's not in the four corners of the contract. But what you're saying is, why doesn't that penalize the lienor coming back on a deductive change order, which has never been presented, has never been agreed to by anyone, and I'm just making an off-the-cuff guess after all the dust is settled. Now that we know what we know on what all that work might have been worth, we look at I'm running out of time. When you look at subsection 3, there's criminal slander in this statute. Yeah. I've got to have all of that willfulness at the moment that the lien gets recorded. And if I've got to,
what case says that, what's your best authority that says it only matters at the time recording, no matter what happens afterwards?
So I would cite pretty much all of them, but Vinci, that's cited in Hayes, all of these, Skidmore, even in Ray Hayes, you look at what the intent of the lienor was when the lien was reported. And because otherwise, if you pay people behind me, I'm at risk of always being a fraudulent lienor. And the lien statute is actually working when you're paying the people, you know, in the contract that they have to admit had to be paid.
Well, there could be two scenarios. Everybody behind you gets paid by the owner without your knowledge at all, or you know about it and you object to it. Right?
Right?
Okay, so in this case, are you saying your client knew nothing about the payments to other lienors downstream from your client that you had included in your lien?
No, they knew that those people were owed that money. That's why it's included in the lien. It's because it's part of the money that's owed under the subcontract.
Correct. What I mean is, did they know that the owner had paid those obligations that your client, so your client has people downstream that as part of your client's subcontract, you have arrangement with other people downstream, you owe them money, you file your lien, you include that in the lien. Then the owner pays some of them, say $10,000. They tell you about it.
Right.
So now you know that your obligation now has been discharged to the amount of $10,000 to that
Right.
person downstream, right?
Correct.
So doesn't your client have an obligation in that scenario where you know about it, saying, well, you know what, my lien includes part of the money that I owe that person, whoever it is, material man, subcontractor, whatever. They just got paid $10,000. I'm now going to amend my lien once I have the knowledge and reduce it by $10,000.
I am so glad you asked that question because I have 90 days to record a lien, after which I can't do anything other than if you tender a partial satisfaction and say, satisfy this lien to $10,000, snap, it's done. That's not what happened here. That's not what happened here. In fact, joint checks being made without requiring partial releases from everybody puzzles me. But this is a record we
Well,
have.
But what prevented your client from doing a partial satisfaction of its own lien?
Nothing, but that's not what makes it a fraudulent lien. It can't.
But that went to good faith in the Edgewater case that everybody's relying on, right? And to that point, isn't good faith in the discretion of the trial judge? And she made specific credibility findings in this case.
She did, but the credibility, when we're talking about the reliance on payments that happened after the liens were recorded, it can't be a credibility question. Those are dates that post-date. To Judge White's point, could you have recorded partial satisfactions along the way? Yes. Did anybody ask us to do that? The record doesn't show that, and that's not what the statute requires.
Well, the statute says any lien asserted under this part. That's the very beginning of subsection 2A.
Right.
Those cases that you mentioned that said the only, because I don't necessarily read that as meaning only at the time you file it. It says any lien asserted under this part, to me, could be construed. I don't know that I saw in the record these arguments on how to interpret the statute or construe it, but how wouldn't that put some obligation, unless, are you saying these cases say, we've looked at any lien asserted under this part, and asserted means at the time of recording, as opposed to asserted means at the time of recording. And then perhaps if, say, someone tells you, oh, by the way, like what if your sub comes to you and say, you know, we just want to come clean with you. We billed you for this work we did. It's actually not incorporated in the project at all. And that's $500,000 of our bill. Do your client have any obligation to release the owner, who has no obligation to your client in privity? It's only by the statute, right? I mean, common law wouldn't, well, maybe it might some common law claims, but there's no privity. At that point, do you say a lienor has no obligation to do a satisfaction of loan when they're told by one of their subs, hey, I defrauded you, but I'm coming clean now?
So let me see if I can digest that. So the 71331 has no requirement in statute to tender or record a partial satisfaction along the way. And there is no statute that says that.
Does any of your cases that you're relying on construe that language, any lien asserted under this part? In
Not,
terms of what does that mean in terms of temporal range? Is it a moment in time? Is it a range in time? Does it depend on the knowledge of the lienor?
Delta Painting, what was the
Okay.
liener's intent in filing the lien?
Okay.
filing, recording, you
And
know,
do they
they use it.
engage in a
Yeah,
statutory interpretation analysis?
no, not on asserted. And then if you go to 3 and you look at the criminal penalty, a person who willfully files a fraudulent lien as defined in this section, it's got to be, the scienter has to be at the filing.
So that statute, the criminal statute limits it to time of filing, but the other statute uses the term asserted, which is a different term, arguably having a different meaning.
It's always been interpreted as what is the willful intent at the time of filing? Because there's nothing in the statute.
For the criminal
Yeah,
penalty.
so the same is built into the 31, the rest of the, as defined in that section. Because every day that somebody's paid behind me, I have a new willful check. If built into the statute, it said along the way, thou shalt record partial satisfactions when you know that somebody's been paid behind you. Okay, that's not what 31 says. It can't be the basis for a fraudulent lien. It's just not in the statute.
It might not be a basis, but doesn't it lend support for the idea of whether someone's acting in good or bad faith? And indeed, that's borne out by the case law.
The good faith, when? The good faith, when you recorded the lien, was that $595,000 of this lien belongs to people behind me. And we know that because they got paid by the direct payments that were made.
I mean, counsel, isn't also an argument to be made the fact that there's a process to adjudicate whether or not there's going to be a set off, and that process is best played out by the time you make your contractual amount that you state you're owed. Then they can say, well, this set off is due to us. Here's our proof of this. Then you can say, okay, we'll take that back.
That is indeed what actually happens when, you know, okay, I went and bought every school job, every public works job, and I'm way over time. Thank you for letting me continue. They're all sorts of direct owner purchases. Okay, they might set the contract here with all the materials to tax exempt the direct purchases. They do deductive change orders along the way, and you've got a dollars and cents number there. Okay, take this off. If they, for whatever reason, disagree on what that number is, okay, now we either do or don't have a good faith dispute over what that number is. But that never happened. And so we're back to, I've got to guess at a number or be subject to $1 million for fraudulently punitive damage award. And it chills my lien rights. I'm not gonna, and that chills all the people behind me who didn't exercise their lien rights and wouldn't have gotten paid.
Ms. Ashby, what's the date that the amended lien was filed again?
April 25th, 2022.
Thank you.
And
That's the amended?
yes, Your
And the
Honor.
first one is like the 22nd, maybe?
Yes, and then payments to Rome, there was 427, 525. These are all spelled out in
In the
the
brief.
initial brief.
I
Yes,
see that. Thank you, ma'am.
yes. And the Johnson Controls payments, the big ones, came in 2023. So
All right, counsel. There were a lot of questions. I'm going to credit you 3 minutes rebuttal time.
thank you. I
Counsel,
appreciate it.
Mr. Herbert, if you're okay, I'll add 10 minutes onto your time to balance it out.
No problem.
Whenever you're ready, counsel.
Good morning. May it please the court. My name is Joseph Herbert, and I'm here on behalf of the appellee, the PHM Group, also represent the surety, which is not a party to the appeal. I have a number of prepared statements, but I wanted to start by addressing some of the questions that I heard from the panel. I want to
Can I
start.
just jump in and completely interrupt you?
Absolutely.
I'm very concerned about what Miss Ashby just described and the point that Judge Nardella just hit. And that is, if there is this much controversy, and I see the dates that Miss Ashby has brought up. They're in the initial brief. They are these joint checks, other than the Tom Barrow check, is post amended claim of lien even, okay? So if we have just where we're sort of guessing, we know the amount that we'd be owed, they closed their permits, they think they completed all of the work. How do we reconcile the idea that this amount should really be the amount that they're owed under the statute and then subject to proof at trial? And then there are set-offs and then the trial judge arrives at that number. How do we balance that with 71331-2A, where it says, any lien asserted under this part in which the lienor has, it says willfully exaggerated, or in which the lienor has willfully included a claim for work not performed. How do we balance those two things to know when a set off is appropriate and when we've got a 2A problem?
The way, and I appreciate the question, the way I think that it works best to do that is to have the trial court do that, make determinations as Your Honor asked and as Judge White asked regarding the timing of how do we determine whether a lien is fraudulent and when the state of mind of the willful exaggeration of a lien is really the question for the court. And from the standpoint that the record reflects that, and this is undisturbed findings, that there were 4 default letters sent in December, January, February, and in April of December of 21, and then January, February, April 22, in the record at 998, that each of those 4 letters indicated to Randall that payments were going to be made to their subcontractors and suppliers directly. So they had notification clearly at that point that they needed to do some inquiry as to whether any of their people had been paid. But the crucial issue is
But they hadn't been at the time of the lien, right?
correct. Although the major thing, the one thing, if we point to and we look at that Randall did know that it never accounted for, as we know from the record, how Randall prepared its lien was no further than this. All it did was look at the contract amount and deduct what it had been paid and filed a lien for the rest.
What's wrong with that? Because this does strike me as being a very common sense way to approach determining the amount on the front end when you know there's going to be litigation in the back end. What do you say to counsel's position that they are left to guess, to estimate, to come up with round numbers? Why should it not be that clear, easy formula? Even if it's wrong, how is using that formula fraudulent?
We have a rubric in place for a good faith dispute.
Okay.
So if the contractor that's filing lien has a good faith dispute, it does an estimate for what it believes or knows at that time should not be subject to its lien. For instance, even Randall admitted, and the trial court found that its estimate was absolutely not credible, that it clearly knew that Coastal had done a substantial amount of work for its benefit. So at the time that it filed the lien, and this is the point I was talking about, the one clear issue that Randall has, is that at the time that either of the liens were filed, it knew that a substantial amount, an enormous amount of its work had been performed by Coastal.
Can you, I know, this is to sound like a really basic question. Why does that matter? Because in my mind, Randall bringing a lawsuit, arguing that you should never have supplemented their work, that they have a contract with the general contractor and the balance of that contract is X. You never should have supplemented them. They're entitled to X. Who cares if you paid Y to somebody else?
The distinction, Judge Nardella, right there is that is a contract claim, not a lien claim.
Okay,
So if for instance, Randall says, you should not have supplemented me, you should not have had the Coastal do my work. That's not a lien claim, that's a contract claim.
okay, so it goes against the general, it doesn't go against the owner.
Correct. And so and what we say is, regardless if you had a contract claim, Randall knew you did not provide that work, you did not provide that materials, you did not perform those services.
So the fact that they stood ready, they never walked off the job, they closed their permits, that doesn't matter?
They did not stand, the undisturbed record evidence is that they did not stand ready, that they had basically abandoned the job.
Okay.
And they're employed, the corporate representative testified that they were ready to quit from near the beginning, and Coastal testified unrebutted testimony that they basically towards the end of the job had.
Okay, so because it's a lien against the owner, we should consider the fact, even though they contested the right to supplement, the fact that they knew it was supplemented should have been deducted because they didn't do that work.
They should have made a good faith estimate of any amount. I mean, we'd be looking at a much different situation had Randall made a good faith estimate of any amount of deduction for work, materials, services that it knew it did not supply to the job.
And then they testify, and I understand that your client takes issue with this, but Randall estimates, you think it's lowballing. Well, hey, that's 60K. And then I guess the trial court gives them the benefit of the doubt on that and finds that indeed it is 60K.
Well, the trial judge, I think, specifically found that that estimate was absolutely not credible. And that Randall knew at the time it was not anywhere near $60,000.
Oh, I think I was just alluding to paragraph 54 of the final judgment where the value for work performed by Coastal that Randall claimed it had estimated at 60K. So what you're saying is very different than what Ms. Ashby is telling us. And that is, she's saying, or at least what I think I heard is, how do we arrive at that number? We don't, we need to prove that. We need to look at that. How do we just arrive at that number? And you're saying this is what they do all day. You have to do a good faith estimate of work that wasn't performed.
You have to, as the contractor who's filing lien, in order to show good faith and not willful exaggeration, you must make some effort to reduce your lien by work and services and materials you know you did not provide to the job. You cannot lien, just like a change order that's unsigned, you cannot lien for work you didn't do and materials you didn't supply. That seems axiomatic from the statute and from the case law.
Did the court make a finding as to whether, because in their initial brief, it asserts very clearly that the work was performed, their permits were closed. Can you show me in the record or does she make some finding about that in the final judgment?
There were findings as far as the work that was performed. The court did make specific findings that the coastal work was in Randall's scope and was necessary and reasonable. Therefore, that work was both in terms of finishing, fixing, remediating Randall's work, that amount, which was essentially undisturbed by, it was unchallenged by Randall at trial, and at this point is undisturbed on appeal, that amount of work performed by Coastal was directly within Randall's scope.
So if we're to agree with you on this point and say, and I keep looking at paragraph 54 of the final judgment, because I think it's where the trial judge really starts laying out the claim about it being fraudulent. For example, it says approximately $40,000 in direct payments for a boiler. I think we've heard Ms. Ashby take issue with that as well for sort of the same reason. Well, you can't just estimate these things. We've got the 60K to Coastal, of course, and then we've got the Tom Barrow about 21K. But if we stopped there, I mean, because that's the only thing that we have before the claim of lien is filed, right? So what I'm concerned about is everything that follows. I'm just not sure it's accurate if where the final judgment says that she, in paragraph 57, these payments were known to Randall during the pendency of the claim of lien encumbering the owner's property and well before the time of filing this action. And I'm sort of thinking, well, based on the statutory language, do we care? And so if we only care about what your client knew at the time that the claim, or even I grant you the amended claim of lien was filed, do we only have this sort of 121K that maybe is arguably de minimis?
No, Your Honor, and there's an excellent point that I'd like to circle back to.
Yeah.
At the tail end of that, but on the front end of Your Honor's question, no, that's not the only the amount, because the 60,000, the trial court agreed that that's what Randall said at trial. It estimated it, but the trial judge specifically found that that testimony was not credible, and that was not a credible estimate at the time by Randall. That they in essence, they did not believe that it was $60,000. That's just what they said at trial. So there's nobody arguing that they did not admit to $60,000 at trial. The finding was that no, they did not credibly believe that was the amount. So it was, and Randall did not, the record does not reflect any amount or evidence presented by Randall to establish what it reasonably believed or evidence to support what it reasonably believed or estimated the actual amount of work and services performed by Coastal was. So we have a black hole where Randall is asking the court to go back and figure out without the benefit of any evidence at the trial court level, what did Randall think that work was really worth? It definitely wasn't, as the trial court found, it wasn't $60,000. trial court ultimately found it was much higher than that, but we don't even know for willfulness standard, Randall did not produce or adduce any evidence at trial to establish that amount. The question at the back end is, I think it's a really interesting legal issue. And as far as I can tell, and from what I hear at the arguments today, it would be a novel question of law for this district and for the state of Florida to answer the question of whether the difference in 713.31 between the criminal and the civil portion as to either asserts a claim of lien or files a claim of lien. I think standard canons of statutory interpretation would state that we have to interpret that to mean that if the legislature used different words, it meant different things. And from that standpoint, I think the trial court took the position, and which we agreed obviously with, was that claim of lien exists as an encumbrance on the property for the entire time. It is asserted all the way through and up until the time that the case is essentially filed and the lien is bonded off. So that lien is asserted that whole time. And this is not a chilling effect for contractors and subcontractors. There is a specific statutory mechanism and procedure for addressing a lien that you later find out should be reduced. And that is partial satisfaction. Nobody has to request that of the subcontractor.
Can you tell me about that? Is that proper for us to consider right now? Because I think that bears on what we're talking about here today. And it's noted in the Edgewater case, like I talked to Ms. Ashby about. And so, number one, I don't really want to talk about it if it's not argued, but it seems relevant. Was it argued? And if so, what's the duty in that regard?
It wasn't argued at the trial level. It is
Or
that.
did you say was not?
Was not the issue of whether the lien the timing of the lien, the only question at that time was what was known at the time of the filing of the lien. But there was an argument by Randall that the trial court should only consider what amounts that it knew had been paid at the time that it filed the original lien. By the way, that lien was entirely replaced by the subsequent amended lien, which is what actually was the basis for the lawsuit. So it would have been the second lien regardless. That first lien was no longer the operative lien. But I think it was not given the same level of legal coverage and argument as we're dealing with today. I think it was an argument that was made that only the amounts prior to the amended or the first claim of lien should be considered. But from the standpoint of the argument at this point, I think Your Honor is correct. It is an important issue and distinction to make, but I'll explain in a moment why it's ultimately immaterial. The question is important, and Edgewater makes clear that subsequent filing of a partial satisfaction is evidence of not willfulness. And it definitely goes and has been considered by courts.
Right, but Judge Isikoff didn't say it was a requirement. She said it's evidence that there was no willfulness here, and she made other findings that evidence was not willful. And I am very interested to hear your partial satisfaction because I think it goes to how we interpret this statute as they're related. But I think the big question is, and I think this rolls into Judge Brownlee's question, is I've heard yet no response to this initial brief statement. I really want to know it. The general contractor erroneously argued to the trial court that the subcontractor was required to reduce its claim of lien for payments made after it was recorded. No portion of the lien law says so. No case law says so. No learned treatise says so.
I think I agree with that position that none of the case law of the learned treatise say that you must reduce your lien subsequent to the filing, but it goes to and is evidence of willfulness. If that were the only issue where they never reduced the lien after the fact, if that were the only issue, I think we would have a much different situation. And this is why I said that ultimately I think it's immaterial. When we go back and look at the time Randall filed the lien, even the original lien, they never took any step whatsoever to reduce the amount that they were claiming by any amount. I mean, the boiler is up, regardless of what I think are sort of extrajudicial comments about whether the boiler was actually available, whether it was purchased by my client. There's no question in the undisturbed record on appeal shows that the boiler was supplied by my client, paid for by my client. There's no question that Randall knew that amounts were paid and expended, that it never made any effort whatsoever to reduce prior to filing one. And then afterwards, when it knew that there had been substantial payments made on its behalf, never took any step to correct any of that at any point in the process. So if we look, there is an absolute dearth of any evidence in the record whatsoever to support a good faith dispute or any good faith conduct by Randall to reduce its lien in any amount.
If we reject an obligation on the back end and we look just at this time period, how would you address Ms. Ashby's argument that's de minimis? What's the continuum that I'm looking at?
If we only look at what was in place at the time of filing either the original claim of lien or the amended claim of lien, the major problem that Randall has right now is that it cannot challenge now or provide at this point evidence that the amount that it knew Coastal had performed on its behalf, it never made any effort whatsoever to reduce that. First of all, I would suggest that even if the number were $120,000, that is not a de minimis.
Counsel, can you talk to us about the requirement to estimate? Because it seems a very difficult obligation that's being put on the appellant here to estimate something. What were they supposed to have done? Sent letters of inquiry? How are they supposed to have estimated the supplementation amount, and why should they have accepted the fact? Why should they be doing that on the front end and not the back end, where there's a process for adjudicating this?
And
I
also,
mean, there's
is there
a real
legal
process for adjudicating this factual matter that the law provides. Sorry.
Mine was piggybacking on hers, and I didn't realize you weren't done, Judge Nardella. I apologize. With what she said, I'm wondering also, is there a legal requirement that you do this, or is this just in practice?
No, I think it is, to answer both of your honest questions. Again, we have to draw a distinction between the contract claims and the lien claims. The lien is a powerful tool. It exists as a encumbrance on the title of the owner, which is in many instances a very serious thing the contractors have to deal with in practice, which is what the case here, that my clients have to undertake to support a cash bond in order to bond off amounts that were absolutely fraudulent, that they had not produced any of that value that the trial court later determined. To answer your honest question, there could be some splitting of hairs about whether a contractor accurately estimates what its lien should be for. But what the statute talks about and looks at is willfulness. What did the contractor know, and what did they intend to do? And what Randall would have needed to do was do something, anything, to reduce its lien by any amount.
But
that it
anything
knew.
would have been a guess.
Anything would have been a guess. And
Wait. Anything would have been a guess that they did to reduce it. It would have been a guess.
Well, Your Honor, I would.
Why should they guess?
I would quibble that they knew that there were certain, and that's why we mentioned in the brief and what's listed in the judgment, is there were certain amounts that they knew boiler, right? That was an item they knew. We did not supply that, $40,000. That's a meaningful amount of money.
But
And
it's anything on the supplementation is a guess.
anything on supplementation, I would suggest, Your Honor, if Randall, and this is the problem we have with the missing evidence that now the appellate court is being asked to sort of look into, is Randall had an opportunity at the time that it filed its lien to do an inquiry, a self-inspection, to talk to its people to say, what things did Coastal do on the job that we have priced into our scope of work that we now can say, we did not do this scope, we did not do this scope, we did not do this, Coastal did those things. It very easily could have taken a look and determined what things it did not do, what materials it did not provide. And it would not have had to necessarily just pluck a number out of the air and guess. It certainly could have reasonably estimated what it knew Coastal had supplied. It took no steps to do that whatsoever.
Counsel, if I may interrupt you, I just have a question on the supplementation, because as I read the order, it wasn't clear to me. I think there could be a different, when you use the term supplementation, it wasn't clear as I read the order. If this work performed by Coastal was work that was part of Randall's scope of work, had never been performed, and Coastal did it. That's what I came away that reading everything, the briefing, the order, the evidence, et cetera. But I don't want to make an assumption. I think that's very different. I mean, I think it's sort of hard for anybody to say, well, we have to guess at what work we know we just didn't do at all. As opposed to if supplementation means the allegation was, well, you did some work, but it didn't comply with the contract document, so we got to bring people in and rip out your work and put in new. That may be a little more difficult for the person who allegedly performed deficient work. Am I reading that? Is there a combination? We had work that had to be removed and replaced, or was it all, from your client's perspective, Randall didn't do this, we got to bring somebody else to do it for them?
There was a certain portion of the Coastal work that was rework. And as the record indicates, that I'm really unfortunate for the project, for the owner, for my client, Coastal testified at trial, and it's in the record, that Randall actually was actively sabotaging them in their efforts by taking and removing the plans, refusing to coordinate with what work it had going on, and otherwise causing problems for Coastal to even supplement its work. And there were references to certain portions of the work that had to be redone, but in large part, I think the record reflects that in large part, maybe in substantial part, that Coastal's work was directly first-time work in the scope of Randall's scope of work. And that is work, again, this was Randall's burden at trial to establish what portions of Coastal's work was brand new rework that it knew, and what portions were rework.
Well, and let me ask you, I guess, a follow-up question on that. So your client's position is under the lien law. If Randall doesn't actually make an improvement to real property, they may have the greatest breach of contract claim in the world. But if they didn't actually improve the owner's real property, they have zero lien, right?
That is absolutely the case.
Now, what about in the case if, let's say, the claim that your client claims deficient work, Randall says our work is perfect, it complies with the contract documents. So you hire supplemental subcontractor, comes in, rips out their work. Let's say at the end of the day, Randall proves, in fact, it was contract compliant and your client made an error. Is the owner liable under the lien law for the work that was torn out to Randall
Yes,
under the lien law?
I think it would be. And,
Okay.
and that falls right within the statute as to willfulness and whether there's a good faith dispute. Whether work is defective or not is subject to good faith dispute. That is, and really this goes to your honor's point as well. It's work that you did, materials you provided, services you performed. There is reasonable basis to disagree about whether that work.
Well, I'm sorry, I'm not
Improve the project.
talking about from a fraudulent lien standpoint. I'm talking about, would the owner be liable for, and in my scenario, bear with me on the scenario, owner's not in cahoots with anybody on this. So contractor breaches the contract, brings in another sub, tears out Randall's work. So that work is not now incorporated in the owner's real property. There's no improvement to the real property made by Randall. Well, there was, but then it was removed completely without fault to the owner. So the owner's liable under the lien law for that?
Yes, that would have been
Okay.
work at the time that Randall supplied it. We'll assume it's a different contractor because that's more of a hypothetical. Yes, the owner would be responsible for that work that was supplied because.
And the remedy would be against the general contractor if the general contractor in fact had made a mistake and it was compliant with the contract document.
Correct.
On the contract.
In your honors hypothetical, the subcontractor there that is the lienor is not removing its own work. It's not tearing its own work out. So
Sure.
it supplied that work to the project and would be entitled to assert a lien for that. No question.
Counsel, can you do me a favor? We've
Yes, sir.
talked a lot about this good faith estimate. Can you point me to the language in the statute I should be looking at? Do you know it off the top of your head? If you don't, that's okay.
I have it in front of me here, Your Honor. With regard to, there's not language in the statute that says good faith estimate.
Okay.
What the language says is any lien asserted under this part in which the liener has willfully exaggerated the amount. So the case law talks.
Oh, so we're
about-
all still looking at 71331. We're not looking at, you're not referencing a separate statute.
No, correct, Your Honor. The case law talks about issues when it evaluates willfulness. It evaluates and looks at all the cases cited, both by appellants and by us. Look at what steps did the contractor or lienor take that illustrate good faith or a good faith dispute or otherwise cut against a finding of willfulness. So that's where we're interpreting, we're using the case law to interpret the standard of willfulness. And in this case, I think Your Honor is right to be concerned. We don't want contractors necessarily having to go out and be held to a really high standard of trying to accurately estimate things that it may not know sort of in the field at the time as things are happening. And I think that's a very fair point to bring up. The courts, when they look at that, they consider all of those factors. What did the lienor know? When did they know it? And what steps did they take to try to not willfully exaggerate their lien? And if the contractor, the lienor, took no steps and knew that it had not supplied substantial amounts, hundreds of thousands of dollars worth of work, that had it accurately estimated that, or even looked at, they didn't even have to estimate, to Your Honor's point, just looked at its sheet, its price sheet of what things it knew it had not done and provided to the project. It could have just checked those items off and left them out of the lien. But instead it did nothing. It asserted every penny as compared to what it originally bid for on the job versus what it was paid. And it knew that it had not paid for and supplied a number of items aside from work that Coastal performed on its behalf. It took no steps, not even to estimate, just to reduce things that it knew it had never provided to the job. That is the level of willfulness we look at when we talk about encumbering someone's property. That's why there is a criminal element to 713.31. Contractors have a powerful tool at their disposal in the lien law. They have an obligation to exercise that power responsibly and reasonably. And may not fine tune our arguments or about whether they knew this or that, as long as they take some steps to show that they were not acting willfully to exaggerate their lien. And while there's no specific requirement after the fact to file a partial release or satisfaction, that is exactly the type of behavior that's evaluated in the case law to suggest that the overstatement was not willful.
You mentioned earlier, however, that you said that you don't believe that matters. That is, if we agree with the appellant that the proper construction of the statute is at the time of the filing, is it your position that if there's any basis for the trial court to have found a fraudulent lien at the time, even if there was error after the fact, that basis now opens up a claim for the damages of the trial court award?
It's a classic tipsy coachman issue, Your Honor, absolutely. If it doesn't really matter, unless the court was interested in planting a flag and establishing potentially new Florida case law on this issue, which I would suggest this might not be a great set of facts to do that on. But if the court's not interested in planting a flag in that respect, all we have to do is go back and look at the fact that at the time of the filing of the lien, Randall knew substantial sums of money. And when it tried to suggest at trial that what it thought the amount that Coastal had supplied was $60,000, the trial court specifically found that testimony not credible and not reliable. So Randall,
I'm sorry to interrupt you, but in terms of planting the flag, I don't recall, but point me to the record. Was this sort of statutory interpretation presentation made to the trial court regarding how this statute is to be construed?
Not directly. Again, the only issue that sort of centered around this a little bit was the issue that appellant argued that the trial court could only consider what was known to Randall at the time it filed its first lien. And we obviously argued that that lien was asserted for the entirety of the period that it was, but again, under the tipsy coachman doctrine, we look back at the fact that we don't even need to really evaluate what happened in between. We know at the time they filed the lien that they willfully.
Well, and then on appeal, what portions of your brief, and if you recall the portions, if not, I'll ask Ms. Ashby when she gets up, where in the briefs is a textualist or otherwise analysis of this statute making an argument that the language either does or does not permit the consideration of knowledge that comes to the lienor's attention after the fact of filing? Terms of the ordinary meaning of the language, construing it with other sections of 713 or any sort of analysis. I recall some arguments that it does permit it or it doesn't, but in terms of an analysis, if you will, where's that?
I don't think either brief really has presented and briefed the issue from a textualist perspective of what the statute permits.
So do you think if we would be planting a flag, so to speak, if no DCA has ever opined on this, or the Florida Supreme Court, that this is the case to do it? Or do you believe the briefing is sufficient on this area of the law? I mean, 713 does have some pretty wide effects in our state with lots of construction going on all the time.
I
I'm a little
think this.
concerned about that. Could you address that concern?
I share your Honor's concern. I think this would be a difficult set of facts and a difficult set of briefing to reach that issue. And the position we took in our briefing, I apologize for going over.
You're fine,
Make sure I
counsel.
address your questions. I think our position is the court never needs to get to that inquiry. That based on the record and the undisturbed findings, the trial court had competent substantial evidence to base its determination there was willful exaggeration of lien. At that point, we need to determine the amount that the exaggeration was by, and the court determined that there was never any value to that lien. But we never need to reach the issue of where do we take that snapshot between the lien and the filing of the actual lawsuit. I think it's an interesting legal question, but I share your Honor's concern that this might not be the case to try to plant that flag and expand into that issue.
Counsel, before you sit down, I have one last one for you.
Absolutely.
We've described this timeline as murky. Randall makes a very clear statement that I want your response to,
Yes, Your Honor.
and they say this: all monies paid to subcontractors, lower tier businesses were paid after subcontractor compiled its claim of lien. Is that true?
I believe that is true. The things that the trial court relied on for willfulness are other than those, which they obviously Randall was unaware that payments were going to be made. But at the time, if we take a snapshot of when the first lien was filed, the major issues and the problem that Randall has on appeal right now is that it has never provided any evidence in support of a reasonable estimate for what work Coastal did on its behalf and what materials and services it performed on.
So
behalf
the
of
coastal factor is a big factor for you guys.
Absolutely. Key issue there, because that was never estimated by Randall at the trial court level. And they knew that it had been performed. They never took any step to account for any of that whatsoever.
But does that really bear on what Coastal is doing, or solely, or does it also bear on work that Randall would not have done? So, because that strikes me as being relevant given the statutory language. So if they know that there is this, big pile of work that Coastal came in and did on their behalf, doesn't it necessarily follow that's work they did not do?
Absolutely. And Your Honor has hit on directly on the head the issue for the claim of lien as compared to the breach of contract, where we might have a dispute, as Judge Nardella pointed out. Can we figure that out later at trial? The issue is, at the time Randall filed the lien, it knew of substantial sums of money for both services, products, and materials. It did not supply to the job. It did not improve that project, and it could not lien forward.
So is it your position then that they had an obligation to estimate that, or that they had to estimate what Coastal did, or is it 6 1/2 dozen?
All Randall needed to do was take a look at what services that it had provided a contract for and a scope of work for. It's listed in the subcontract, what its amounts were and its scopes of work. All it had to do was talk to its supervisors in the field, figure out what work and materials it did not provide and deduct those from its lien. It could have definitely and should have asserted those as a breach of contract claim, but it could not have properly included those in a claim of
Well,
lien.
not to split hairs, counsel, but is that what the trial judge found? When she said this, the value of the work performed by Coastal that Randall claimed it had estimated at $60,000. Is that a finding that Randall didn't do $60,000 worth of work? Or was that a separate finding she needed to make for that point to be sustained on appeal?
There's a separate finding. I think and I can find for your honor, there were specific findings that the $60,000 was not a credible estimate and that Randall's corporate representative providing that estimate.
I see it, counsel. Thank you.
No problem.
All right, counsel, thank you so much for your argument. We're gonna bring back
My
Miss
pleasure.
Ashby, and I'm gonna credit her. I think we're 13 minutes. Let's see. We'll just do 13 plus 7, and we'll go to the 20-minute mark. Is that okay, counsel? Does that make sense?
I'm here and grateful for the court's time and the opportunity to have oral argument in person. It's fabulous. Thank you. To Judge White's point, this is a very, very important issue. It is,
Is this the case to plant the flag on?
well,
Make your best argument why it shouldn't be uncomfortable, given to me, if it was preserved, very minimal. And then the presentation on appeal from a statutory analysis and interpretation standpoint. Address that concern that, yes, this is the case to go one way or the other, either for your client or the appellee's client, but to plant a flag, here's what the statute.
right. So in answer to your question, it is a 7-figure case to Randall Mechanical. It's we're not here over $21,000. This is a very important case for the appellant. So yes, the answer has to be yes. In Bassiano versus Bankers Trust, which I get it was a 5th DCA, not a 6th DCA case, the court asked counsel at oral argument for additional briefing and issued an order with some specific questions, answered these questions, tight time frame, tight brief schedule. I'm just saying that's a possibility that I would like to suggest, and I would certainly be up for that. This is only the 3rd time I've argued off of somebody else's briefs, and I'm not trying to disparage anybody. It's just, I know that the issues that we've talked about today, you have some very pointed questions, and I would very much like the opportunity to address those. Going to the final judgment. And
If I could stop you there,
Of course.
let's assume for the sake of the question, certainly I can't speak for my colleagues, and I haven't decided. I'm thinking about this. That's why I'm asking a question. But let's assume one of our considerations would be, well, does it matter? So appellee argues it doesn't matter because even under your client's construction of the statute, and that is it's at the time of the filing, there is competent substantial evidence that supports the trial court finding that under the statute at the time, there's at least one basis in the statute to find this lien is fraudulent. And therefore, now under the statute, the party who is the beneficiary of that fraudulent lien, that's the right term, beneficiary of a fraudulent lien, but the appellee now has a damages claim. And so we don't have to get to the planting the flag. There's a basis, and it's an affirmative. It's what the appellee are.
right, so yes, I am very familiar with PCA, and I understand that it is appropriate when there isn't a reversible error shown. In this case, the arguments upon which the trial court ruled that's in the final judgment inescapably. These were the bases that the trial court used for a finding of fraudulent lien. That finding could or could not come with punitive damages. In this case, it came with punitive damages being the maximum amount that's allowable under the statute. And paragraph 8 on page 16 of the final judgment relies upon the finding that Randall reported the lien with full knowledge that PHM had paid Randall's subcontractors and suppliers directly substantial amounts which form the basis of the lien. Can't be so. It can't be so. This is not Superman turning the earth backwards. Time tells us that at the time the lien, both of them were reported. With one exception, those checks hadn't even been written yet. Some of them weren't even written until the following year.
But couldn't that be talking about Coastal recorded a lien with full knowledge that labor, and I don't know, I'm asking, and forces alongside which its forces worked for months. So that presumably would be Coastal, not joint checks, right?
This is, I'm referring to paragraph 8 on. page
Okay, I'm on
16.
7.
Yes, sorry. Randall's subcontractors and suppliers. Impossible for that to be Coastal. And if I can also jump in and add on how is a lienor, Randall or any lienor, to make an assessment of whether there's I'm agreeing there is a right to a set off first. And I'm supposed to be able to estimate what that amount is because nobody.
No,
can tell
counsel.
me that.
Is it a question of set off? Is that a contractual question? So the main position by your opponent is the fact that set off is a matter of contract and we shouldn't look to contract law and whether or not you have a value due under the contract, and maybe we can dispute that later. This is a lien you put on the owner. Can you address that foundational issue for us?
Yeah, I mean, you have to have a contract and your lien has to be based on that contract. And so do we have deductive change orders required by the contract that resets what my contract balance, what my total amount of the contract is? It certainly works in favor of the owner and for the general contractor, they're going to bond it off. So says Skidmore and Hobbs, but it doesn't work if it's a deductive change order going to the boiler issue, because that's an identified issue. Coastal being on site, they're working under Randall's permits, under its license, okay? This isn't, well, I'm gonna pick on these square boxes of what may be soundproofing and say, well, you put 2 in, but they put the other 6. It's not that defined. It's not, well, we did this room and this room take off costs this amount of money. But first of all, when you bring in another subcontractor, it's always going to be more expensive. And there is nothing in the statute. There's lots of arteries in chapter 713. An owner can ask a lienor for what are you owed, so I can make direct payments and I can ask those questions. I have no right to ask sideways. I can't go to Coastal as a subcontractor asking another subcontractor, what do you have in this job? What are you working on? I have no contractual right. I have no statutory right.
But you can look at what you've done, right? So I'm troubled by, I can't figure out quite yet the interplay between what you are saying, which I think is well taken. We're just pulling this estimate, out of thin air. And then but that's, we've got this statutory language. The statutory language doesn't talk about contract amount. The statutory language says fraudulent lien when you have included a claim for work not performed. So doesn't your client have some duty, some good faith estimate rather than just like pulling numbers out of the air, which I take your point would be ridiculous. Regardless of whether it could go to Coastal, couldn't it look to its own records and say, we did this, this, and this, we should have gotten hypothetically $1 million for the deal, but we only put in, 3/4 of that. Don't you have some good faith obligation to see what kind of work you put in, given that specific statutory language?
Yes, and the record shows that they achieved substantial completion. This is an ACA project. You know how particular ACA is?
Did she
So-
find that there was substantial compliance with the contract and that they performed?
She found that there was a breach in favor of PHM. And so, yeah, we're now at the end of the lawsuit. And so we're going back to the time that the lien was filed and, foreshadowing what the end of the lawsuit is going to show on that good faith dispute over what's owed under this contract.
But what steps, is there something in the record that tells us what steps your client took to say what sort of work that they performed on the contract.
Yes. When, the first day, when the Randall representative testified, he said, we take the contract, the total contract sum. This is not a case where, oh, you forgot to include deductive change orders that were executed or anything like that. And then we deduct the paid amount and that becomes the lien claim because we have substantially performed and we've closed out the permits. And so that is how these things go. If there is a good faith dispute over whether, well, you know what, we've got some set-offs because you weren't working fast enough and we brought in some extra manpower to try to get this thing punched out quicker. Okay, but that doesn't roll back the hands of time and make your lien fraudulent, because then every single lien, with the possible exception of Materialman, will be subject to a fraudulent lien on that basis. Because if there's any, and that's why in 1990,
But Ms. Ashby, if I can interrupt you.
Sir.
Let's assume we accept your argument about what happened, that the statute doesn't permit a finding of a fraudulent lien to be based solely on what happened after the filing. This trial court, in this final judgment, made a finding that's, I'll just summarize. At the time of filing, your client knew, full knowledge, knew that at the time it filed, that part of that lien, which was for its entire contract minus money it actually received, that's the amount, even though it knew there is some work that we are now putting in this amount of our scope of work that has not been performed. We haven't done it. We know it. We have full knowledge at the time. So, which is why Applee argues, well, you don't have to get to the question of, did they know about, payments made to other people afterwards and they should have reduced their already recorded lien. This is at the time of recording. This is what happened. That's what the trial judge did. How can we reverse that finding? And I don't even know if it's argued that we can reverse that finding. But so if that finding stands, doesn't that finding in and of itself, that means the lien is fraudulent, right?
no,
Why not?
because the finding is, if I may, paragraph 7 on page 16 of the final judgment, Randall recorded the lien with full knowledge that supplemental labor and forces alongside which its forces worked for months actually performed substantial portions of its scope of work. That's the finding. And so.
Well, and then paragraph 6, though, also says that Randall caused to be recorded under which it claimed entitlement for performance in supplying 100% of the work and materials under its subcontract. It was owed every dollar and cent for the amount paid by PHM out of the balance of its subcontract.
Correct.
When it knew at that time, reading the findings, the trial court found it knew it hadn't performed everything under its contract. Am I missing something there? But I mean, your client had not fully performed at the time it recorded everything under its contract, right?
It had substantially completed the project and there was no counter evidence that the permits weren't closed out. And so to find
But
that
that's fine.
supplemental labor it makes it a willful knowingness. So I've got a 3-judge panel, but you know what? I'd like a 5-judge panel. I bring 2 other judges in here and I know there are 2 other judges. But I don't agree that I need 2 other judges. I have 3 super intelligent people here now. I don't need the supplemental forces. And that doesn't necessarily, we're talking about going back to
I understand
my
it doesn't.
intent when I.
Hold on for a second. I
Yes.
understand it doesn't necessarily, but this final judgment is replete with credibility findings and findings of your client's testimony being not credible, unpersuasive,
Understood.
which permits the trial court can draw inferences from that. That yes, you might have said that you had no knowledge, you had this. I find you're being disingenuous with me and you're hiding it. And in fact, you knew everything about it. That happens all the time
I
with
understand.
juries and judges, right? I mean, it seems pretty clear. I didn't see these witnesses. how can I reverse a trial court who sat there, saw the whites of their eyes, saw whether they're sweating or not, their demeanor on the stand, and all of those things that appellate judges are completely unsuited for? How can I reverse these factual findings on a finding that at the time you had full knowledge that you had not incorporated into this real property everything you're saying here in this amount?
It all holds back to the trial court applying the wrong standard and misconstruing 713-31 as a matter of law. And
At the time?
Excuse me. Final judgment says that the fraudulent lien component part, the biggest component part is that we knew that the people behind us had been paid, and that is untrue. So we know that's wrong. And then we knew that Coastal was there doing work, other work, that nobody told us how much it was costing. And this is the good faith dispute about whether they were supposed to, that they needed them or not. But this goes back to, we knew they were working, and we must agree to that set off. The minute we're recording a claim of lien, otherwise I'm willfully exaggerating. What does a good faith dispute savings clause mean? When that was enacted in 1990 for just these reasons, so that every lien doesn't turn into a fraudulent lien with a waterfall cascading of a bad result. The lien law will be as dead as Crestview, Florida. Sorry to pick on them if they were on TV. So, in terms of just going dead, and the lien law exists in Florida, and Florida's lien law is complex. I'll give you that, of course, but we have been the poster child for all the other states, starting with the state of Georgia, on how to get it right. And if the fraudulent lien statute gets ripped open, like every good faith dispute turns the gas on the lienor, as a lien lawyer, we're going to have to say, look, you can lien it, but good luck, because if the court finds they pay people behind you after you lien, and that relates back in time to a willfulness, your license is in peril. That's a third-degree felony. This is big stuff. It's important. So back to your original question, is this the case? It's got to be the case. It's a lot of money. It's not $10,000, $12,000. And it's really boiled into this final judgment that the trial court relied on $595,000 worth of payments that were made after the lien was reported, which is one of the reasons why the lien law exists, is to get people paid who deserve
So
it.
the argument is, we don't know if the trial court considered this as a fully baked cake, or if we can just take out one of these findings and say this alone sustains it.
It's a big number.
Yeah. Counsel, I asked you something really basic that your opponent made a point of, and that's the difference between contract and lien. I'll go back to it. I think so my example would be this, my hypothetical. If Randall gets locked out of a job site, they can't perform. Contractually, they're owed 1.5 million. But they didn't perform after the first day because they got locked out, right? They have a great contract claim against the general. Do they have a lien for the contractual amount owed in that example?
Do they have a contract? Do they have a lien for let's say they got locked out at 50%. Do they have a lien for the contract balance, the whole enchilada, or just the 50%?
Yes, ma'am.
They have lien rights for the improvements.
That they
Okay.
made.
Correct.
It's only the
So only the
50%.
50%.
Correct.
Okay. The other 50, they can go sue for it, reach a contract with the general, but they can't lien for the other 50.
Subject to specially fabricated materials that are on site. And I mean, yes, but just to try to make it simpler to answer your question, you have to show for your lien rights, the improvement to the property. Okay. And if you build it and it's half a courthouse and, it's still 50%, even if to the owner, it's worth nothing because it's half built. But yes, so, you're saying, okay, well, you didn't perform all the work because Coastal was out there. That doesn't mean that Randall didn't perform the work. There's no dispute that they closed out the permits. And as I said, it's an ACA project. This is not fly by night. They're very, very particular. So that was the testimony, is that there was substantial completion.
The
And
trial court rejected it. Didn't believe it.
And y'all you didn't challenge her finding with regard to Randall breaching, right? So,
correct,
okay, so we can't really consider that, am I right? That last point about, well,
as it goes to the willfulness component of fraudulent lien, yes.
okay.
Thank you so much.
That'll round our time. Ms. Ashby, Mr. Herbert, I very much appreciate you guys staying and giving us the full benefit of an argument today.